right.
As it pleases the court, my lord, I still confirm my appearance on behalf of accused number 4.
Sorry, my lord, I'm appearing on behalf of Mr. Ntanzi, not accused number 2.
Okay.
Yes, thank you.
My lord, I appear on behalf of accused number 5.
Yes. Yes.
As the court please, my lord, 2 issues stood out yesterday. The first issue regards Section 105A of the Criminal Procedure Act.
Right.
There was a debate as to whether this issue was covered in the evidence.
Yeah.
And we just wish to refer the court to the relevant portions where this issue was canvassed. It's pages 57, 15.
Wait. Page 57.
Yes, 57 and 58, as well as 59, page 59.
Okay. Which date?
On the 21st of November, 2024. Yes. And, my lord, the sole issue why we canvass or we re-examine Brigadier Gininda on Section 105 was to demonstrate that it is the defense that elicited this information, and that despite Brigadier Gininda sounding a word of caution that he may not traverse the issue of Section 105, that the defense of their own bed pursued this line of cross-examination. Now, yesterday, Brigadier Gininda explained the import of Section 105A, and we're not going to take it further than that, my lord. The law regarding Section 105A is very clear that once the negotiations fall through, that no further reference may be made to those negotiations. And we just wish to draw the court's attention to page 58 of the proceedings of the 21st of November 2024, where Brigadier Gininda on page, in fact, starting on page 57, line 20, Advocate Mnisi says, thank you. Now I just want to paraphrase what we have just said now so that I'm able to follow you, and the rest of the discussion follows. But what we want to focus on, my lord, is page 58, the answer by Brigadier Gininda that the discussions was insofar as I am capable to go there, my lord, because I was told by the prosecution that because those discussions in terms of Section 105A were not finalized, one should not venture into that. We just wanted to place that on record through the examination of Brigadier Gininda.
No, but how was the question posed to elicit the answer, which you say Brigadier Gininda proffered?
Yes. So we're not going to take...
No, how was it posed?
Yes.
Did it make reference to 105A?
Yes. It starts on page 57, my lord, by Advocate Mnisi on the 21st of November 2024, line 20. Mr. Mnisi, thank you. Now, I just want to paraphrase what you have just said now so that I'm able to follow you. You are saying on the 23rd, there was a discussion between accused two's attorney and himself with the prosecutors for a confession that was supposed to, or about a confession that had to be taken at 24 June 2020. Not so. Then Brigadier Gininda then gives the answer that I've just placed on record. Then Advocate Mnisi proceeds on page 58 at line 20. Now, on the 16th, accused to get arrested by Mohani and Mabena on the 18th as per your version. You are meeting him at Carltonville, where you hear that, where you heard, or should be heard, where you had that interview with him. On the 19th, he appears before Rapadu, 19th June 2020. He appears before Rapadu for an alleged confession. On 23 June, there is an attorney, there's Mr. Mjiako, and Mr. Mjiako now appears at the scene or in the act, and there are those little arrangements that we have discussed about the possible plea bargaining arrangement and the confession. Now, this was after Brigadier Gininda sounded that word of caution. And furthermore, on the same page, my Lord, at line 21, Advocate Mnisi says, maybe before I proceed, on 23 June, when there was this attorney, Mr. Mjiako, made an arrangement with the state with regard to a possible plea bargain and a subsequent confession. Were you part of the discussions? This is the information, my Lord, that we, through re-examination of Brigadier Gininda, that we wanted to put on record. Thank you. Then the second issue, my Lord, is regarding the state re-examination of Brigadier Gininda on the additional photos that were downloaded on the cell phones of accused number 2 and accused number 3. There was an objection by the defense, and the state wished to then deal with that aspect, my Lord. And to that end, we've prepared brief heads of argument to deal with those aspects. My Lord, in the introduction, paragraph 1.1, we mentioned that the state is currently busy with the
kade khona ke indaba kakhuluma ngayo ke umele ihlangothi election labeshushizi lana ke udaba lokuthi kade khona ke inkulumo kade khona iqhamukile ngesikhathi esimlusolo qala bahlangana khona ke nofakazi uBrigadier Gininda lapho ke la ithizine ngaphambi ukuthi enze confession futhi ukuthi enze ke isivumelwano secala ke lapho ke ngesikhathi ade behlanganele bonke kushuthi lapho ke isivumelwano ukuvuma icala noma isivumelwano secala ke lapho ke esiwela ngaphansi komthetho ka section 105 ke lapho ke la kade khona bathi lakhuluma ngodaba lokuthi bona ke beyafisa ukuthi babuze ufakazi malana nemibuzo eqhamukile kulo daba lokho bese bathi ke ngembangelo ukuthi lokuzana ke isivumelwano leso singakaze senzekeke akumele ukuthi baqhubeke babe sebebuza imibuzo kulo hlangothi lolonke manje uyasho khona ukuthi khona ke inkulumo ayibhalile ethe wayilungisa ke lapho ke malana nodaba loyithombe ke lezi abayijobelele ngaphakathi kwezithombe lezi bekuvele sezikhona ke ithombe esiqwa khona ke lapho ke umsola wesibili ke futhi nomsola wesithathu ke athi khona njalo ubhale inkulumo lena ngoba ofisa ukuthi ayifundele inkosi enkantolo ke ngoba athole ke bese ngemuva kwalokho athole ke ushuthi isicelo sakhe ke lesasibhalile bese ngemuva kwalokho athole mhlawumbe ukuthi inkosi enkantolo yakuvuma yini ekuthizini aqhubeka abuze ufakazi ngemibuzo ngodaba lezithombe ade lokhona ke phakathi kocingo lakamsola wesibili futhi nomsola wesithathu.
Now in paragraph 1.1, my Lord, in the introduction we mentioned that the state is currently busy with the re-examination of Brigadier Gininda, and we seek to re-examine him on certain additional photos of accused number 2 and 3 that were extracted from their cell phone downloads. And we mentioned, my Lord, that the sole purpose of such re-examination is to put a full and fair picture before the court to enable the court to adjudicate on the issues that are in dispute, namely the identity of the perpetrators who invaded the Khumalo's home on the 26th of October 2014 and killed the deceased, It is our submission, my Lord, therefore, that the evidence is relevant. In paragraph 1.3, we mentioned that the defense has raised an objection against this evidence on the basis that it is new evidence that was not canvassed during cross-examination by defense counsels.
Bekafuna kubana lo daba lencwadi kayibhalile lapho kuthizeni kusenkantolo enjineli thizeni abuzeke ufakazi babo Brigadier Gininda ke imibuzo mayana nodaba ithombe lezi thize bazijobelela ke kuyithombe kade zikhona ke cha izithombe zalapho ke zakamsolo wesibili futhi nomsolo wesithathu athi khona ke lapho ke usuthi uma iqala ke inkulumo yakhe lapho ke ngaphansi kodaba loqala athi bekacela futhi bekathanda futhi uyazi ukuthi khona ke njalo ubaba uBrigadier Gininda uyena ko ngaphansi kwesifungo njengamanje ke futhi bekathanda ukuthi kambuze ke aqhubeke futhi ambuze ke imibuzo mala nodaba ithombe lezo thize basijobelela lana kule licala leli ke ephicelezi equka khona kumsolo wesibili futhi nomsolo wesithathu ke ithombe lezo bazithubulile ucingweni noma kumakhala kukhwini wabo ke iyasho khona ukuthi imbangela noma inhloso ukuthi benze lokhu ke ukuthi afuna ukuthi icala leli ke lehlale kahle phambi kwenkantolo futhi ngendlela ejwayelekile futhi ngendlela eqondile mayelana nodaba lokuthi lapho ke basho khona ke abantu abangena ke ngaphakathi kwalomuzo kaKhumalo ke ngelanga la nge26 kaOctober ngomnyaka 2014 bese babulela khona ke lapho ke umufi waqhubeka washo khona wathi lokhu kubulungiswa mhlawumbe ufakazi obukhethekile futhi obuhambisana necala leli ke washo khona ukuthi kepha ke ihlangothi noma ithimba ke labameli ke likunqabile kuthizeni bona baqhamukise ke ithombe lezi ke ngoba wathi ufakazi obusha ke lobo futhi bona abakaze bakhulume abakaze bakhulumisana ke ngodaba lolu.
Now, my Lord, we contend that the issue of identification and description of suspects was canvassed in cross-examination, and that insofar as accused number 3 is concerned, his counsel did traverse the issue as to the appearance of accused number 3 on page 87 of the record of the 29th of November 2024. And we quote the relevant passage where Adv Mnisi states as follows: "Thank you, Brigadier. I will not take issue with the usage of terms like identification and description. At least now you are explaining it that you actually meant to say description. But when I read it, I said identity. Identified means you just go and have a common thing like to go and point it out. Do you understand? But thank you for the explanation. It eases my mind." Then Mr. Gininda understood, my Lord. Advocate Mnisi, thank you. Now let us proceed. Photos downloaded taken of the accused by himself, and in brackets selfies, match the description of the suspect who had the firearm with dreadlocks, big eyes with gold teeth. Let us pause there. Then Brigadier Gininda, yes, my Lord, I'm listening. Then Advocate Mnisi, thank you. Now let us go to I think it is Exhibit S, the downloaded pictures. Brigadier Gininda, yes. Advocate Mnisi. Just of the downloaded, yes. Now I'm going to request you to meticulously go through Exhibit S. As I told you initially, sir, that this is an affidavit, and you really would understand better as a manager in subs what an affidavit and what it is, and that is being said in an affidavit entail, and what is said in the affidavit entail. But having said that, let us go to Exhibit S. You take us through those photos, those downloaded photos that were taken by the accused himself with dreadlocks, big eyes, and with golden teeth. And we have bolded these portions. We can request the state to page for us so that the accused persons can also follow. Start with the first picture. Now, these pictures of accused number 3 that we seek to re-examine Brigadier Gininda on talk to this description that Advocate Mnisi is touching on here. Then Brigadier Gininda answers, yes, my lord. So which part do you want me to describe? All the pictures that are now under this exhibit. Then Advocate Mnisi, okay. Let me leave you to do your own identification of the picture that has the accused, that has the suspect who is now said to be accused 3, and we've bolded that portion, with dreadlocks, big eyes, and with golden teeth. From the downloaded pictures as information that you told the magistrate. Then Brigadier Gininda. Yeah, so my lord, firstly, so I will identify those pictures, but firstly remember, sorry my lord, my apologies, what I wanted to say, this is summary, and we close the quotation. Now, insofar as accused number 2 is concerned, the issue of his identity was canvassed as follows by Mr. Ramsepeli on the record of 13 November 2024 at page 63. He says the identity kit was compiled. Makalani is the only person that gave the description of suspect B. Then Brigadier Gininda, my lord, if I can just have a second. I just want to check something, a second or two. Then Mr. Ramsepeli, I can quickly assist you. The first witness is Ms. Kelly Kumalo. If you look at the last 2 sentences, she says, Mrs. Steenkamp, Kelly Kumalo could not describe the second suspect. Do you see that, Brigadier Gininda? Yes, I do see that. Then Mr. Ramsepeli, yes. Then Brigadier Gininda, and we've bolded the response of Brigadier Gininda. That is exactly where I wanted to go in terms of describing or could not give the profile. But as I said, you take this in relation to the statements as well. Because in the statements, as much as they are not giving marks in terms of their identity kit that was compiled by a warrant of sustained camp, but they do indicate more or less how the second intruder was. But insofar as the compilation by warrant of sustained camp, yes, we are in agreement. They did not say it, but insofar as the statements are concerned, they do give an indication as to how the second suspect was looking like and what he may be carrying. We therefore submit, my lord, that the identification and description of the suspects who intruded the Kumalo's house on the 26th of October has been the main focus of the cross-examination of Brigadier Gininda, and therefore falls within the ambit of section 1661 of Act 51 of 1977 as being, and we quote, any matter raised during the cross-examination of that witness. We close the quotation. We contend, my lord, that as these are photos of accused number 2 and 3 that relate to their appearance and will assist the court in adjudicating the identity of the assailants who barged into the Kumalo's home on the 26th of October 2014, the photos will serve to put a full and fair picture before court. Then paragraph 1.5. In the alternative, my lord, we submit that even if the re-examination of Brigadier Gininda on these additional photos can be regarded as new matters that do not arise out of cross-examination of Brigadier Gininda, we submit that the new evidence can still be canvassed with the leave of the court, and the court may allow further cross-examination on the new evidence. And in this regard, we refer to the well-known Handbook of Detoy and others, Commentary on the Criminal Procedure Act, the 2024 edition, pages 22 to 96. And furthermore, we make the submission that should such evidence be regarded as hearsay evidence, the Hearsay Act does allow for provisional admission of hearsay evidence subject to the downloaders being recalled.
Kade asho khona ke njalo ihlangothi lomethimba labashushisi ke lapho likhuluma ngodaba lolwethombe phecelezi ithombe lezi equka khona ke lapho ke umsola wesithathu ke lapho ke futhi asho khona nje athi mangabe bekhuluma ke ngodaba loluke udaba loluke athi balukhuluma ngesikhathi sakhe bebuza ke imibuzo ke abameli benu la ngaphansi kwenkantolo qhubeka asho khona nje athi lapho ke uma bebuka lapho ke mala nelanga noma ngoba nenkulumo ekhulunywa ngelanga la nge-29 November ngomnyaka 2024 ukuthi uadvocate Mnisi lapho wathi ngiyabonga brigadier angeke abesahambela ke noma nodabaluke malana nendlela kade bemchaza ngayo ke umuntu makade emkhuluma ngayo umuntu noma isikhangiso somuntu kade khona ke lapho ke wathi ke mangaba uma angaqhubeka futhi asho khona njalo ke manje namaphuzu akhe futhi yazwisisa ukuthi lokho mhlawumbe ufakazi angabeka akukhuluma ngokwakhe ke wathi ufakazi yebo ngiyabonga futhi athi singaqhubeka lapho ke uma bekhuluma nodaba lwethombe bakhuluma khona ngokumalana nodaba lwethombe zakamsolo wakhe lezi umsolo ayithatha yena ke mathupha ngokwakhe futhi selfie ithombe ayithubula ephethe ucingo lwakhe futhi sekathatha ithombe mabamba ucingo ngalendlela elandelayo athi mhlawumbe bambe phone ngalendlela bese uthatha ithombe lapho ke isikhangiso leso basibiza ukuthi selfie ke lapho ke bathi umuntu leke wena umuntu wangena ngaphakathi kula khaya lomuzo wakwakhumalo ke lapho ke ephethe ke isibhamu ke futhi kade yana ama-dreads kena ke futhi bakana mehlo amakhulu futhi bakade nezinyo legolide la kena ke kumazinyo akhe ke bese wathi ubhekade yagina yebo ngilalele ke Nkosi enkantolo mayiqhubeka khona kanjalo mayiqhubeka khona njalo ke inkulumo khona ke sengaphambili ke bathi abakhe babuke ke ithombe kade zingaphansi kwemibukiso ka SK lapho ke ngesikhathi kade bedownloadile ithombe zakhona bathi ubhekade yagina yebo uyezwa lapho ke wabe khona njalo bese waqala ke lapho bayidownloada bese waqala wathi na ke athanda kamceleke uthi akhuluma phecelezi ngethombe lezi ezikhona ke lapho ke ngaphansi kwemibukiso ka S lapho ke athi yebo ngiyakuzwa ke mhlompheki noma ke mnumzana uma bebuka ke ithombe lezo shuthi bakhulu isithombe kade bezibhaliwe lapho ke noma kade zihambisana nodaba David ke lapho ke ithombe zathi bethule ngaphansi kucingo lolwa kamsolo wakhe noma lo muntu bathi bakana ama-dreads futhi anamehlo amakhulu futhi nezinyo legolide ke kena ke futhi bathi ithombe lezi zikhona ke ngaphansi koshicilelo noma ngaphansi kobufakazi ade bukhona ke la ngapha noma ngaphansi kwemibukiso ubufakazi ade bukhona ke lapho ke wathi bese wathi umnumzana Mnisi yena kuyakuzwa ke lokho ke kepha yathanda ukuthi ufakazi buye ke osikhokhelayo noma kulolu daba lokuthi asitshele balana nalo muntu othizeni ade besola ukuthi umsola wesithathu ke lo muntu loyo ke futhi kade nama-dress ke kena ke futhi anamehlo amakhulu futhi nezinyo legolide kena ke bese wadownloada ithombe zakhona bese bazidlala ngaphambi kwenkantolo ke lapho ke wathi yebo ngiyakuzwa kepha khumula khona njalo bese ufakazi wakhuluma khona lapho ke wathi yebo ngiyakuzwa kepha kuma sesikhuluma ngedaba lethombe lapho ke into ayikhumula ukuthi lapho ke bese wathi uyaxolisa ke lapho ke waqala futhi ngenzansi kancane nje ngokugcwele ke noma mhlawumbe uma sekasamaraza ke inkulumo yakhe lapho ke washo wathi khona uma ngabe sikakhuluma ke ngomsolo wesibili ke lapho ke lecala leli ke lapho ke bese nje wakhuluma ngodaba lwakhe ke lapho ngesikhathi umnumzana Ramsipile bekakhuluma ngelanga la nge-13 zaka November ngomnyaka 2024 uma ngabe ukake inkulumo yakhe kwikhasi le-63 ke lapho ke kulaba khuluma khona ke ngale kit ade begcwalisile ke thombe lapho ke agcwasa ke lapho umnumzana uMakeleni ke umuntu wakhona ke futhi wachaza nesikhangiso salabantu laba ke okhona ke lapho ke usuthu umsola wesibili ke lapho suspect B ke lapho ke bekwathi ubrigadier yagini lapho yebo Nkosi enkantolo ngiyakuzwa kepha kuba ngathola nje umzuzu odwa ke ekuthizeni ngibheke lokho okulandelayo nomhlanje imizuzwana emibili ke lapho ke bezathi umuntu Ramsipile yebo mina ke kepha ngiyakusiza ngokusheshsha ke lapho ke ngoba khumula khona njalo ukuthi kufakazi oqala ke lapho ke ukheli Khumalo akakaze ke akhona ukukhuluma ke ngendlela uma busubuka lapho ku sentence kama sentence kamabili ke kade abhale lapho uStian Kampu ukuthi akakaze asho ke indlela umuntu wesibili bekajangala ngakhona bese isikhangiso solomuntu wesibili ke athi yebo ngiyakuzwa futhi washo khona njalo ungabe seyaqeda ke inkulumo yakhe wathi lamagama kahle kahle bekafisa ukuthi awakhulumela malana nesikhangiso salomuntu ngoba uma sabheka lapho ukuthi profile yakhe lokho adazama ukuveza noma ukusho nodouble statement lapho ke ngoba khumula khona nje statement lesingesikhathi ade sibhala lapho kumnumzana noma warrant officer Stian Kampu ngesikhathi bekabhala lapho akakaze asho noma washo lokho kulandelayo ukuthi lapho ke nanoma nake akakaze athule ke lokho ugcwele ke malana nodaba lwakhe ke futhi akuvumelana naye futhi ahambisana inkulumo akhe ikhona ke ummeli ke lapho ke kepha washo ukuthi uma ngabe ungaze ubuke lapho ke malana nethombe zakamsolo wesibili ukuthi wathi akakaze kangeneke leli khaya leliyana waqhubeka washo khona njalo inkulumo khona ukuthi uma ngabe ke bebheka lapho ke izithombe lezike eziwela la ngaphansi kumibukiso kaS lapho ke ukuthi ithombe zichaza ke abantu abangena ngaphakathi kolomuzo kaKhumalo ke ngelanga la nge-26 October ngomnyaka 2014 ngesikhathi sakhe bengena ke lapho ke futhi uBrigadier wakhuluma ke malama nodaba lolo ke bathi likhona ke ngaphansi komthetho section 166 subsection 1 act 51 of 1977 ukuthi lo daba lolo udaba ke olusha ukuthi bangaqala ke baliveze ngaphambi kwenkosi yenkantolo ngoba selibakhulumile ke ngalo futhi bathanda ukuthi bakhulume phecelezi nezithombe zakamsola wesibili futhi nomsola wesithathu ke lapho ke la bekhuluma khona ngodaba lwakhe noma ngokuthi ke yibona abantu abasola ukuthi bangena ngaphakathi kwalelikhaya noma kwekhaya lomndeni wakaKhumalo ngelanga la nge-26 zaka October ngomnyaka 2014 ngoba kade bebachazile ngesikhangiso sabo futhi ngendlela ababonakala ngayo noma ngendlela abatshengakala ngayo ke lapho ke waqhubeka washo khona wathi lo daba asukuthi udaba oqala nje njengamanje nje ukuthi balikhulume futhi sele balikhulumile ngaphambili futhi washo khona ukuthi umthetho uyavuma ngaphansi komthetho futhi wazogcina ubukisa ngecala ke lapho ke icala lapho la kaDutoti futhi nabanye ke lapho ke elwela ngaphansi komthetho futhi icala ukuthi umthetho omusha ke abaqhamkisile ke lapho ngomnyaka 2024 usuthi uma uka kwikhasi la khona ke lesi22 kuze kufinye kwikhasi lesi96 kula ubona khona ke malana nalo fakazi athanda ukuthi abuqhamkise ukuzana ithimba labashushisi ukuthi lecala la kaDutoti lahambisana icala lakhe azama ukuthi noma afisa ukuthi aqhakuse ngaphambi kwenkantolo futhi ashikona ukuthi inkulumo abayizwayo ukuthi ke ivumelekile ukuthi inkosi yenkantolo iyamukele esikhathini samanje kuze kufinye la bathola khona ke ufakazi ogcwele ngesikhathi leso.
Now in paragraph point number 2 we briefly deal with the legal position regarding re-examination and we refer to the case of S versus Ramolope 1995-1 SACR 616, that is the decision of the now Supreme Court of Appeal, and we just wish to refer to on page 5 of our heads the third paragraph starting with the words, as far as the right to re-examine a witness is concerned, the operative words in section 166(1) are on any matter raised during the cross-examination of that witness. And paragraph 4 says 2 points emerge from an analysis of the quoted words. First, there is a statutory right to re-examine on any matter if it is raised during cross-examination. Then the court went on to look at the definition of the words, and it held as follows: these are words of very wide compass, any being a word of wide and unqualified generality. Secondly, the right to re-examine a witness on any matter is only limited to the extent that it was a matter raised during the cross-examination of that witness. The contextual meaning of any matter raised during cross-examination of that witness cannot, in my view, reasonably lead to misunderstanding. Raise means to bring up a question or point, to bring forward a difficulty, objection, etc., to advance a claim. And we wish to then refer to page 6 of our heads, my Lord, the second paragraph, and this talks to the purpose of re-examination. The Supreme Court of Appeal summarized the purpose of re-examination as follows. Generally speaking, the object of re-examination is to clear up any point or misunderstanding which may have occurred during cross-examination, to correct wrong impressions or false perceptions which may have been created in the course of cross-examination, to give the witness a fair opportunity to explain answers given by him under cross-examination, which, if unexplained, may create a wrong impression or be used to arrive at false deductions. And in the following, my Lord, we emphasize this object of re-examination to put before the court the full picture and context of facts elicited during cross-examination, or to give the witness an opportunity to correct patent mistakes made under cross-examination. And what is important, my Lord, the court said that these examples of the object of re-examination are not intended to be numerous clauses. Re-examination can be and frequently is a very important mechanism for presenting a full and fair picture of the evidence of a witness and thus of arriving at the truth. That is, my Lord, what we're trying with the current exercise that we've embarked upon with Brigadier Gininda. Of course, if counsel wishes to deal with new matter that is not arising from cross-examination, he requires the leave of the court to do so, and this is the request that we're making in the alternative, my Lord, that should this additional photos be regarded as new evidence, we request the leave of the court to canvass them with Brigadier Gininda. Then in point number 3, we deal with the reason why the evidence was not led in examination in chief. And 3.1, we point out that the reason why the evidence was not presented during evidence in chief is that it was only during the long adjournment that was afforded to Advocate Mnisi to prepare his cross-examination that the state was able to go through the over 700 photos of the downloads, and that a disc concerning these downloads was given to the defense some time ago. We surmise that it was in 2023, subject to correction. The state has now extracted 3 additional photos from the cell phone downloads of accused number 3 and 16 additional photos of accused number 2 that we want to show to the court. We mentioned, my Lord, that accused number 2 and 3 do not dispute that their cell phones from which the downloads were made, that these cell phones belong to them. The photos belong to accused number 2 and 3 and therefore fall within their personal knowledge. And in paragraph 3.2, my Lord, we make the point, as we did yesterday, that a witness can give viva voce evidence and also use photos to demonstrate his evidence as real evidence. Now, lastly, we deal with the interest of justice. In paragraph 4.1, we submit, my Lord, that it is in the interest of justice to allow this evidence, as it will assist the court to adjudicate on the issues that are in dispute, and that the evidence is therefore relevant. Paragraph 4.2, we deal with the locus classicus of R versus Hepworth, 1928, AD 265, 277, that has been repeatedly referred to during these proceedings. Namely, that criminal proceedings are not a game in which one side is entitled to claim the benefit of any omission or mistake made by the other party. The duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice was done. And we refer to the case of Sheikh and others. The reference is there, where the court held that the applicants stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsection 35, 3A to O of the Constitution, the right to a fair trial requires a substantive rather than a formal or textual approach. It is clear also that fairness is not a one-way street conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused as well as those distressed by the audacity and horror of crime. And we also refer to the case of multi-choice and others versus the National Prosecuting Authority. And we just want to refer the court on what is stated on page 8 of our heads, where the court referred to the case of Zukuza and others, and held that the right to a fair trial is a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair criminal trial and what infuses its purpose is for justice to be done and also to be seen to be done. And lastly, we refer to the case of Dlamini and others. And the reference is given there where Judge Krichler in the Constitutional Court described the phrase interests of justice as a useful term denoting in broad and evocative language a value judgment of what will be fair and just to all concerned. We therefore respectfully submit, my Lord, that the state be allowed to re-examine, sorry, there's a typing error there, to re-examine the witness on this additional photos. Well, before I sit down, I just want to mention that there's another aspect, and we just deem it appropriate maybe to bring it to the court's attention at this point so that we don't argue these matters piecemeal. There's a footage that the state is waiting for from ENCA regarding the proposition that was put by Mr. Mngomezulu to the witnesses, namely that the deceased was shot by Mr. Longo Twala, and that in the process he shot himself in the foot. There's a footage that is available, my Lord, that we want to show to the court. We have started this process since December of 2024 to obtain this footage, but there's a certain procedure that is involved. There's an agreement that was entered with the South African National Editors Forum, SANEF, in terms of which the permission of the Director of Public Prosecution must first be sought before a subpoena can be issued against any journalist. We started this process in 2024, and the NDPP did give authorization, and Section 205 subpoena was issued for the footage. But there's been toing and froing with the legal representative of ENCA. But about 2 days ago, my Lord, they undertook to furnish the state with the footage, and we also want to take Brigadier Gininda through the footage. It's a 2 minutes footage that will not take long, my lord, and we just want to include that, my lord, as part of the state's request to re-examine Brigadier Gininda on that footage. It wasn't specifically canvassed during cross-examination. It's a new matter, and we seek the court's permission to, as soon as it comes to hand, to re-examine Brigadier Gininda on that footage. As the court pleases.
Yes, Adv Mnisi, any response?
Thank you, madam. I will
Yako library, until the case in. Please. The main library.
I will start with the last aspect on the footage. We would request that even before that footage is made available for purposes of the proceedings, request that the state should disclose it to the defense, and I'm saying that on behalf of accused number 1 and 3, so that we can go through that footage with a view to prepare meaningfully our defense with regard to that piece of evidence. The state is well within its rights to request an indulgence from the court to open its case in an event new evidence that is relevant comes forward. That will be up to what the court will decide. This court will have a discretion in that regard. That is my submission with regard to the last aspect. On the application that has just been moved by the state, the issue indeed has been canvassed yesterday. Just to give a bit of a background, the state indicated that he indicated when he gave us the photos that he who doesn't hear me? The state indicated that it had communicated to the defense that it would want to use these photos in re-examination. That was an address from the bar. That is soon after the state had beamed a photo of that picture on the big screen, and then I stood up and I raised an objection and indicated that this would constitute new evidence. That is when the argument about the fact that there was a discussion between the state and the defense that will be canvassed in re-examination. Apparently that information was not, or that submission was not supported by the defense counsels. In an endeavor to support that submission, the state then went to what I would call an email message that was purportedly sent to the defense. He read out that message to court, and the message did not confirm what the state said, that he indicated to the defense that he wanted to raise that message, that issue in re-examination. So I'm not so sure how the issue was then resolved, but the impression that was created to me was that in any event, that picture that the state sought to lead constituted new evidence, and the state needed to bring an application or indulgence to reopen its case in order to introduce that evidence, such that it cannot be introduced.
Sorry, you're saying the state, wait, sorry. You're submitting that the state should reopen its case.
No, I'm saying the
You
state...
never said that.
I'm saying the state should make an application, request the court's indulgence to reopen its case for the introduction of that new evidence. It cannot
The state has not closed its case. That's factually the situation now.
Yes, my lord.
Yes.
I'm talking specifically with regard to this new evidence. I'm saying the state cannot introduce this new evidence in re-examination.
Fine.
Yes. Now, the state today brings this application to be allowed to re-examine also on the basis of this new evidence. We have objected yesterday, and we indicated the basis of our objection, my lord. Now, when one looks at the heading of the state's application, it reads, Heads, re-examination of Brigadier Kininda on the additional photos of accused number 1 and number 2. Now, immediately the state concedes that this constitutes new evidence. State refers to Exhibit S. The photos that the state wants to re-examine Brigadier Kininda on are photos that are not contained in Exhibit S. When the state went through the downloads of accused number 1 as per of accused number 3 as per the allegation, there were more than 700 photos that were found in the downloads. But then the state, in the presentation of its case, then decided to identify certain photos and compiled Exhibit S, which in its view was enough to come and present its case based on that particular evidence. The state also indicates on paragraph 3 that the reason why such evidence was not led in examination in chief was because they were able to identify further photos at the time at which I was afforded the opportunity to go and read that very big record of proceedings. They were able to identify those extra photos, and they now want to introduce them through re-examination. Our view is that is unprocedural, my lord. As much as we admit that we realize that there's nothing that is stopping the state from accusing that evidence, but that evidence cannot be introduced through re-examination. Procedurally, the state needs to finalize its re-examination, made an application to the court for the leading of this new evidence, which is to be contextualized in its case. Now, the issue with regarding to the photos, I just want to contextualize this based on the extracts that the state referred to. There was a point when I cross-examined Brigadier Kininda, and I took him through his affidavit, the affidavit that he brought, that he prepared for the application of the warrant of arrest against accused number 3. Now, in that affidavit, he mentioned, amongst others, that the suspect who got into the house, who had a gun in his possession, had dreadlocks, had big eyes, and had a golden teeth. Now, with that description, I then requested Brigadier Kininda to assist this court by referring to the compiled or to the prepared Exhibit S in its entirety on all the photos that were contained in Exhibit S and identify these traits or these marks which he alleges in his affidavit that they match accused number 3, which were the dreadlocks, the big eyes, and the golden teeth. He then started to page through Exhibit S. As he was paging through Exhibit S, he came across a photo of a person which had a golden teeth. And then he said that was accused number 3. When I took instructions from accused number 3, I'm not so sure whether I put this on record. Accused number 3 then said to me, yes, this is my younger brother or elder brother or something like that. But that was after Brigadier Kininda had said, no, this is what is being referred to in my affidavit, that this is the person who had a golden teeth. And indeed, the person who had a golden teeth in Exhibit S was there, and accused number 3 said this was my younger brother or something like that. I'm speaking under correction in terms of whether it was an elder brother or a younger brother, my lord. Now, that was basically the essence of this identification in terms of Exhibit S. Now, that was closed. These photos that the state would then want to lead this evidence on now are not part of Exhibit S, and as such were not referred to in Brigadier's evidence in chief. As such, Brigadier Kininda was not cross-examined on them because they were not part of Exhibit S. It never anticipated that at some stage in the future the state would then come and use them. We don't say if the state says, yeah, no, we now deem them to be relevant, we want to use them. That is their discretion. But the point that you are mentioning is that Brigadier Kininda cannot, or the state cannot introduce that evidence through re-examination. As I've said, the state would have to close its case, finalize its re-examination on Brigadier Kininda, request an indulgence for the court to introduce this new evidence. That it will be outside our ambit. That will be the duty of the court with the discretion that it will have to exercise. We understand that the state's case has not been closed. That would have happened even if after the state's case was closed, my lord. All that we are saying now is that this information cannot be introduced through re-examination. It must be introduced by virtue of examination in chief, and we be afforded the opportunity to cross-examine Brigadier Kininda. Otherwise, the procedure that the state wants this court to embark upon is very precarious, my lords. And I realize that the state says, let the court allow us to re-examine Brigadier Kininda also on this additional information. That will be wrong. we realize that the state is saying, let the court allow us to reopen our case, to reopen our examination in chief, so that we lead Brigadier Gininda on those photos. That is in the discretion of the court, my lord. Whether the reason that they've submitted or not are sufficient, it will be for the court to decide. That will be my submission.
Yes, Mr. Ramsipili.
If it may please the court, my lord. My lord, at the outset, my dilemma would be this. Advocate Baloyi says the 16 additional photos in respect of Mr. Ntanzi that he now seeks to use in re-examination of Brigadier Gininda were downloaded from the cell phone of Mr. Ntanzi. Now the court normally says we listen to the evidence, and the evidence that I've listened to from Colonel Stein, Mr. House, is that the cell phone of accused of Mr. Ntanzi, the Samsung cell phone, was password locked or PIN code locked, and it was not analyzed. Whatever information that was downloaded in respect of Mr. Ntanzi was from his memory card. And this brings me to the point when these photos were disclosed to us by Advocate Baloyi in April. I asked him, what is the source of these photos that you now seek to introduce? And an answer was not prophet, my lord. So my starting point is from there, because now it will look like after Stein has testified, that phone was opened and further 16 photos were downloaded therefrom, and now the state seeks to use them. We don't know who the downloader was. There's no affidavit of the downloader, the date when it was downloaded, because as far as I know and I'm aware, the cell phone is password locked, my lord. That is my starting point. And the second point, my lord, and I'll concur with Advocate Mnisi, is that this is new evidence. Section 166, section 1, is very clear on re-examination. Re-examination, the purpose thereof, is to clarify points that emanate from cross-examination on matters that were raised in cross-examination. These photos, the 16 photos in respect of Mr. Ntanzi, I've never referred Brigadier Gininda or any other witness in my defense of Mr. Ntanzi to these photos. These photos, I only saw them for the first time in April, my lord. Now, my lord, my submission is that, and as Advocate Mnisi has stated, my lord, the state must make a proper application whereby the downloader of the 16 photos in particular must be recalled in their application to come and give context as to the source of the photos, an affidavit be made, and he testify under oath so that we know where those photos emanate from in respect of Mr. Ntanzi. Otherwise, my lord, to seek now in re-examination to introduce those photos when we haven't tested the downloader or the analyst, that will be tantamount, my lord, I submit respectfully, to putting the cart before the horse. Brigadier Gininda cannot testify about the photos before the analyst, cannot be testify about the photos in re-examination in particular, where the analyst of that photos have never testified in chief about those photos, my lord. And further, my lord, yesterday I even said this. These photos, inclusive of Mr. Ngube, they do not form part of Exhibit S. Exhibit S was only limited to about 49 pages, 49 photos or so, my lord. My memory escapes me as to the actual number of photos that were in Exhibit S. Now, further, my lord, I hear that the state intends to also lead evidence of a footage, my Lord. My submission on that one is brief. We will cross that bridge when it arrives. I mean, the state says there's still toing and froing between relevant counsel on that aspect. So we'll cross that bridge when we get there. As the court decides.
Yes, Mr. Moore.
My Lord, yesterday afternoon, just before we close for the business of the day, I was invited to make submission on the very same subject. On the very same subject. And my Lord, I'll reiterate what I said yesterday, that if the state wished to introduce this piece of evidence, there must be an application for the reopening of the state case. And if I recall very well, that is after my submission, the court even remarked, directing those remarks to the state, to say that if they want to introduce this evidence, there must be an application for the reopening of the state case. So it looks like now we are going back to the very same issue that we dealt with yesterday, going in circles, no progress at all.
Okay.
Those are my submission, my Lord. Thank you.
Mr. Mshololo.
As the court pleases, my Lord. My Lord, I just got two submissions, my Lord, to make. On the introduction of a new evidence, my Lord, I submit that the state is supposed to bring the application for the recalling of Mr. Mabaso, who is the one who introduced the Exhibit S, my Lord, which contained the photo album that is before this court. Therefore, my Lord, my submission is that from the submissions made by the state, it is not clear the reason why these pictures were not presented by the same witness, which is Mr. Mabaso, at the time when he testified. Because the state is, in paragraph 3, my Lord, is making submissions to say the state was in possession of these pictures at the time when Mr. Mabaso testified. But as to the reason why this information, this new evidence that they intend to introduce now was not presented, it is not included in the submissions by the state, my Lord. My Lord, secondly, the new evidence by law can be introduced at any stage, even during the state case or even after the defense case, but provided a proper application is made before the court, and the reasons for the failure to include such information or evidence are placed before court. Because if that is not done, my Lord, it affects a right to a fair trial of an accused person, in that he had not been given an opportunity to present and to prepare and to conduct his case on the evidence that has been presented before court. If such a new evidence is presented at this stage, the right to a fair trial of an accused is automatically violated, my Lord, because he has presented his case without knowing that this information, this portion of evidence will be used against him in order to prepare his defense case adequately. Thirdly, my Lord, the witness who is before this court now is not the witness who presented the Exhibit S before this court. Therefore, my Lord, the new evidence cannot be introduced through this witness. Even if the court can grant the state such a leave to introduce a new evidence, but it has to be introduced by Mr. Mabaso, who is the one who introduced the pictures which are contained in Exhibit S, my Lord. Yeah, thank you, my Lord. Those were my submissions.
Okay, any response?
Bafowethu naloku kudaba.
Sorry.
udaba olukhona-ke manje kuwukuthi kunofakazi inhlangothi noma ithimba-ke labashushisile ngathanda liqhamukise ngaphambi kwenkosi yenkantolo-ke ufakazi obuhamba mayelana noma ufakazi ophukama phakathi-ke iy'thombe lezo-ke bakhuluma ngazo-ke ezakaMshololo wesibili-ke lapho umnumzana uNtanzi futhi nomnumzana-ke uMncubeke. Kepha-ke ithimba labameli benu liyanqaba ekuthizeni-ke ithimba labashushisi-ke liqhamuke ngalolo daba lokho ngoba ubufakazi lo khona-ke manje Brigadier Gininda bathi akena-ke umuntu kade adownloada-ke iy'thombe lezo ngaphakathi ocingolweni noma kwamakhalekhukhwini benu-ke lapho-ke bathi umnumzana kuMabaso kade asenza-ke lo msebenzi loyo-ke futhi kwamele ukuthi kube khona-ke izizathu lapho-ke ezikhona-ke futhi noma izathu ezibekwa ngaphambili kuqala ukuthi kungani befisa ukuthi balethe kufakazi lobo futhi bathi-ke abameli benu-ke lapho-ke kumele ukuthi kube umnumzana uMabaso ukuqala okuwukuthi uyena-ke oza nale thombe lezi bese abhale i-affidavit bese asho ukuthi athathe iy'thombe lezo zithole kuphi nendawo noma wasithola kuphi-ke ngaphambi kokuthi ufakazi uBrigadier Gininda-ke babuze imibuzo ukuthi bathi akusuye oze nezithombe lezi kepha-ke akube umnumzana uMabaso ngoba kade kuye bekazile futhi uye bagcwalisa imibukiso ka-exhibit S usho ukuthi lapho-ke kade khona-ke izithombe lezo kade zikhona la ngaphambi kwenkosi yenkantolo njengofakazi kade bukhona-ke manje athi uma ngabe ithimba-ke labashushisi lifisa ukuthi-ke lohole noma lihambe kulolo daba lokuthi ziyoqhamuka ufakazi obusha-ke kwamele ukuthi lapho-ke benze-ke isicelo ngokukhethekile futhi ngokusemthethweni ngoba-ke banalo ilungelo lokuthi-ke lapho-ke benze isicelo uma ngabe icala lisahleli ngaphambi kwenkantolo noma icala uma ngabe selifike emaphethelweni-ke lapho-ke futhi banqaba-ke ukuthi njengamanje bakhulume ngakho kepha bathi lo msebenzi loyo-ke suthi isinqumo soqhamuka kwinkosi yenkantolo.
Yes, any response?
As a court, please, my lord, my colleague Dr. Sibanda is going to reply to the issues that were raised. I just want to point out one aspect, my lord, regarding the argument of Advocate Mnisi.
Is that allowed, sir?
As a court, please, I'll leave it to Dr. Sibanda.
No, you are the one addressing this court.
Yes.
Now you're saying you are abdicating that position.
No.
Your colleague should take over. I'm asking, is that allowed?
Well, I think if there are two counsel in the case, they can address different issues as they arise. Yes.
Right, but you address that issue first.
Yes, of the
and argued it
of section 166. Yes.
Now you're saying your learned colleague should take over. All I want to know, is it justified in terms of our law?
Well, there's as I mentioned, counsel can divide the work amongst themselves.
You are right. But you don't leave an argument hanging in the air.
Yes.
And then I continue.
Yes.
You read that case, State versus...
Yes. The court did refer to that, yes.
Yeah, Hatzenbeck, he was sitting here, actually.
Yes.
Hatzenbeck, when he made that decision.
Yeah.
1975, I think.
Yes, but it's no problem at all, my lord.
No, it's not me, it's the law.
Yes.
Anything I say, Mina, it's the law. I don't make decisions based on nothing.
Yes.
If you could persuade me that it is allowed, we can adjourn.
Yes.
If you can persuade me that it's allowed.
We don't want to
present an argument, and then in response, you say your learned colleague should take over.
Yes.
We all know you are in the same matter.
Yes. If my memory serves me well, that case of Eisenberg said two counsel cannot cross-examine the same witness.
Yeah.
But there's nothing that stops counsel from...
Eisenberg was a brilliant jurist. You can't shaft him because he was talking about two counsels not presenting evidence in the same matter. Two. There were certain reasons why he did that.
Yes.
And the fact that he was speaking about the presentation of a case and not the argument in terms of the law.
Yes.
You can't say it's not relevant also.
Yes. But
that's why I say I can adjourn, you must...
Malat, really, we don't really want to make an issue out of this.
Okay, fine.
I will address those issues. The first one is the point raised by Advocate Mnisi that the state must first conduct the re-examination of Brigadier Gininda, then thereafter make a fresh application for the reopening of or make an application to lead further evidence. I hope I understood him correctly.
Yeah,
and
that's how I understand it.
and I think that is a point that was also buttressed by Advocate Mshololo and I think the rest of council.
Yeah.
My Lord, the point is this: if one looks at Section 166, it says with the leave of the court,
Yeah, it says that.
any evidence can be led. It doesn't restrict the leading of such new evidence to any specific point. So it extends to any evidence that is sought to be led. And my Lord, we want to make the point that it will really be circuitous to lead Brigadier Gininda just on certain aspects, let him to stand down and bring a fresh application that certain evidence be led. I think that would be, and we say this with the greatest of respect, that would be a waste of court's time and a waste of resources. The Constitution is clear that this we see in Section 173, my Lord, that the Constitutional Court, the Supreme Court of Appeal, and the High Courts have the inherent power to protect and regulate their own process. We therefore submit, my Lord, that it will be perfectly permissible should the application be granted to lead Brigadier Gininda on these photos. We've mentioned, my Lord, in our heads that should this evidence be regarded as hearsay evidence, we will bring an application for the downloaders, namely Sergeant Mabasa and Orandov Sandlovu, to be recalled regarding the totality of the photos that were downloaded. It is indeed so, my Lord, that Exhibit S contained photos that were selected from, the totality of the photos at the request of Brigadier Gininda, just to show certain features of accused number 3, but the rest of the photos are there, and we have made them available to the defense. Colonel House, in his affidavit, does canvass, and this page 13 of his affidavit, that the photos were retrieved from the disk or memory card of accused number 2, and I'm really baffled by the submission of Mr. Of my colleague, Mr. Ramsepeli, that he asked us as to the source and that we couldn't finish the answer. I mean, we told him, we even, in fact, he's the one who said it's Colonel House, and I said, yes, this Colonel House. But anyway, we are the last people to want to cast aspersions. We therefore submit, my Lord, that the application ought to be granted, and we stand by those submissions, my Lord.
Mr. Ramsipili says he doesn't even know where these photos come from.
Well,
In other words, they could have been picked up in a dustbin, as far as he's concerned.
well, we just want to refer the court to the proceedings of the 16th of April 2024, page 18.
Yeah.
And there's the evidence of Warrant Officer Ndlovu, the downloader of the cell phone of accused number 2, wherein he testified as follows regarding that submission by Mr. Ramsipili. Says also the cell phone has one SD card, memory card, then all 2 SIM cards and the SD card were successfully extracted with XRY forensic tool. The then cell phone itself was unsuccessfully extracted due to the fact that it had a pattern, as Mr. Ramsipili mentioned. Then he carries on at line 20. Then the results were burnt on a CD and sealed in a forensic bag. He gives the forensic bag number. Then it was kept into the safe, waiting to be collected by the investigating officer. This is the source of those photos, and we further wish to refer to the proceedings of the 23rd of May 2024, page 103.
Okay.
This is the cross-examination of Mr. Ramsipili of Mr. House, line line 7. Mr. Ramsipili says, so I'm not going to go through picture by picture. I'm just going to summarize them as you have written them in paragraph 7.31. In respect for this paragraph, that accused will tell the court that the photos depicted on pages 13, 14, 16, 17, 18, and 21, which were according to the data created, accessed, and edited on 4 January 2021, were not done by him because he did not have this device on him at the time. Then Colonel Ho says, I cannot comment. Then Mr. Ramsipili, okay. And similarly with the screenshot in terms of section, paragraph 7.3.2, and the newspaper article in paragraph 7.3.3, accused 1 will deny that he's the one that accessed, modified, and created those images. In summary, my lord, we're saying that there is evidence already before the court regarding the downloading of the totality of those photos, and if need be, we will call the downloaders regarding the authenticity of these photos that we want to present before the court. So, God bless.
So, if I understand the defense, you are not averse to the application to recall the evidence regarding the photos which Mr. Balui allegedly wants to introduce into the case. You are not adverse, you are just saying this is not the opportune time to do it. Am I understanding everybody like that?
My lord, certainly we cannot stop the state from leading evidence that they think it's material to their case and relevant, yes.
Is that how you understand your position? So,
That is correct, my lord. Thank you.
Yes, my lord, that is correct. But I've also raised, my lord, the issue of the reasons why that evidence was not raised before, was not introduced before, that it must be based on record. Thank you, my lord. The reasons why this evidence was not introduced by that witness when he was testifying. Thank you.
Are these people still alive?
Of course.
Ndlovu
And Mabasa.
Mabasa, they still alive.
Yes, of course, my lord.
In South Africa, we die every day. So where do they live? I mean, or stations?
Yeah.
Are they in Gauteng or?
Well, Sergeant Mabasa is in Gauteng, but Warren of St. Love is in Mpumalanga in Middelburg. But I'm told that they can be here next week.
They can be?
They can be here next week.
Next week.
Yes.
Okay. Are you still going to call any other witness besides them?
No, my lord. Just we indicated that Brigadier Gininda is our last witness. We don't intend to.
No, you just told me you got
Yes,
some footage.
Yes. Well, that will. Once we receive the footage, we'll obviously, as Advocate Mnisi requested, we'll be giving the footage to the defense, hear what the standpoint is, and take it from there, my lord.
Okay, fine. Now I will accede to this application by the defense so that people can physically see the court is fair. So the application to cross-examine or re-examine Brigadier Gininda on the basis of the photographs which were encapsulated in Exhibit S, is that so? It's different, that evidence, from what the state now wants to lead. You want to lead 3 other photos, is that not so?
For accused number 3 is 3 photos and 16 photos for accused number 2.
Okay, fine. Yeah, so the court rules that you have to bring a proper application as requested by the defense. Okay.
As a court, please, my lord.
But it would be helpful for this court to read the judgment of Klute. I don't know if you've read it, but this is the leading judgment in this type of application. S versus van der Westhuizen, 2011 to SACR 26. It's a useful judgment. This guy was sitting with the lady who used to be a colleague of mine, but she's now deceased, Snyders and Teron. S versus van der Westhuizen, 2011 to SACR 26. This judgment traces Canadian law, English law, and talks about everything a prosecutor should do and not do, and also the objections allegedly raised by defenders. Okay, so after this, what do we do?
Well, there's only one aspect that we want to re-examine Brigadier Gininda on.
Is that so?
Yes, and we'll then ask him to stand down until the process that we've referred to is
Okay,
finalized.
let's hear.
manje inkonzo enkantolo ke bafowethu nayo ke manje ihambisana ke nabameli benu ekuthizeni ke uma ngabe ihlangothi noma ithimba ke labashushisi ke lifisa ekuthizeni liqhamukisa kofakazi obusha ukuthi kumele benzeke isicelo lapho ke mayelana nezithombe lezi kaMshololo wesibili futhi nomnumzana wesithathu lapho sithi umnumzana uNtanzi futhi nomnumzana uNcubeke mayelana nodaba labo lezithombe ke lezi ethomba ke ezikamnumzana lapho ke ulukuzana umncube wathi zintathu izithombe zakhe ke yapha ithomba zakamnumzana uNtanzi futhi ezishumi nesithupha ke lezi bangathanda ukuthi ithimba labashushisi ke liqhamukise ubufakazi balo manje lithi into senkantolo ke ihambisana nesicelo sabameli benu ethizeli ithimba labashushisi kwamele benze isicelo kahle ngokukhethekile ke uma ngabe efisa ukuqhamukisa ubufakazi obusha.
Okay.
Brigadier Gininda, in a nutshell, Your evidence amounts to the following, that after receiving a report from Mr. Absalom Zungu regarding accused number 1 and 2, that you profile them, and accused number 1 is arrested on the 30th of May, and he makes a confession as per exhibit FF.
Athi ke manje umshushisi usho ukuthi mayelana ngemuva kokuthola ke udaba noma ureport oyithola kubaba Absalom Zungu mayelana nomsola oqala futhi nomsola wesibili ke bese ke ngemuva kwalokho ke shuthi wena ke wenza profiling yabo ke lapho ke bese umsola oqala ke yaboshwa ke lapho ke ngelanga la ke 30 zaka May ngemuva kokuthi yaboshwe ke njalo ke bese wenza confession.
That is correct, my lord.
Athi yebo kunjalo.
And in that confession exhibit FF, he mentions a traditional healer, Mr. Lionel Zwane.
Bathi ngaphakathi ke confession ayenzile kula khulume khona ke ngesangoma ke lapho noma inyanga ke lapho ke umnumzana uLion Zwane athi yebo.
That is correct, my lord.
And you then trace this Mr. Zwane with the assistance of accused number 1.
Bese ke nahamba ke nomcinga ke umnumzana
on the
uZwane ke
31st of May 2020.
bese ke nahamba ke nomcinga ke bese namthola ke umnumzana uZwane lapho lenzwane futhi uphelekezwa komsolo oqala noma usizwa yena ke namthola ke ngelanga la nge31 zaka May.
That is correct, my lord.
Athi yebo kunjalo.
And accused number 2 is also arrested, and as a result of the 2 confessions made by accused number 2, you were able to profile accused number 3, 4, and 5.
Bathi ke ngemuva kwalokho kwabese kuboshwa ke lapho komnumzana uNtanzi ngemuva ukuthi uboshwe komnumzana uNtanzi ke lapho ke bathi ngemuva ukuthi ubophe umnumzana uNtanzi ngabe wakhona ukuprofile umsola wesithathu nowesine futhi nowesihlanu.
That is correct, my lord.
Athi yebo.
And you were able to find evidence against accused number 3 up to accused number 5.
Ngabe bokhona yini ukuthola ufakazi mayana nomsola wesithathu umsola wesine futhi nomsola wesihlanu ke?
That is correct, my lord.
Athi yebo.
Inter alia, the downloads of accused number 5 that indicates the 2 calls made, the downloads of Ms. Kelly Kumalo's phone.
That is correct, my lord.
082704435, and the 2 calls that accused number 5 made to her.
That is correct, my lord, specifically on the 2nd of August 2014 and 15 October 2014, my lord.
Athi ke ngemuva kwalokho sothola ke uxhumana ocingweni phakathi koKelly Khumalo futhi ke nomsolo wesihlanu ke bexhumana ke ocingweni ke ihlandlo ezimbili athi yebo kunjalo ke ngomnyaka 2014.
And that the phone or the cell phone number of accused number 5 was initially deleted on the phone of Ms. Kelly Khumalo, but was eventually recovered.
That is correct, my lord.
Bathi ke inombolo zocingo zakamsola wesihlanu kade zicishiwe ngaphakathi kocingo lakaKelly Khumalo kepha ngemuva ukuthi nenze kumsebenzi yona phina nabuya nazithola futhi ngaphakathi kocingo lwakhe athi yebo kunjalo.
And that the number of accused number 5 was saved as NA on the phone of Ms. Khumalo.
That is correct, my lord.
Bathi ke inombolo zocingo zakamsola wesihlanu ke lapho kade bezibhale ngo-NA nje kuphela bengabhali igama eligcwele phakathi kocingo lwakaKelly Khumalo athi yebo kunjalo.
And furthermore, that accused number 3 was arrested on the Cleveland case 1561 of 2015, and a firearm and cell phone were recovered from him during his arrest.
Bathi lapho komsola wesithathu waboshwa eboshela icala seCleveland le case 156-1/2015 eboshela phatha ke isibhamu ke lapho ke firearm and what?
And a cell phone.
Futhi nocingo ke lapho ke.
Yeah, yes, my lord, but the case number, I think that case number relates to the Alexander case. The case number for Cleveland is Cleveland 96/2/2015.
Yeah, sorry about that, yes.
Athi ucabanga ukuthi leke icala le case number le kade ibizile komshushisi case number lapho ke Alexandra ke kepha ke case number se Cleveland 96/2/2015.
And that this firearm that was found during the arrest of accused number 3 in his possession is ballistically linked to the bullet point that was found on the scene as testified to by Colonel Mangena.
bathi ke sibhamlisa bamthule naso ke umsolo oqala umsolo wesithathu manje aqala la lapho ke Cleveland ke usho ukuthi isibhamlisa kodwa kade nenzeka noma ke inhlolo kusona ke shuthi ama ballistic report ke lapho ke futhi bathi sona sibhamlisa sidubulile lapho ke ngelanga lile kade dudula komufi ngabe kunjalo yini?
Yes, that is correct, my lord.
Athi yebo kunjalo.
Now, without the information that was furnished by accused number 2, would you have been able to identify and connect accused number 3 up to number 5?
Bathi ngaphandle nje kolwazi owalithola ke kumsola wesibili ke ngabe bongakhona yini ekuthizeni uxhumana noma uthole umsola wesithathu maqedwe somthola umsola wesithathu bese uthole kowesine futhi nowesihlanu?
No, my lord. It was a difficulty at that stage.
Athi cha kade kunzima ke lokho ngesikhathi leso.
And the cell phone records of accused number 3 were also obtained that showed his movement on the day in question and his communication with accused number 5.
Bathi ke lapho ke nathola ke uhamba nathola ucingo la kamsola wesithathu. Ngemuva kokuthola ucingo lomsola lwesithathu ke lapho ke nathola ukuthi bekahamba kuphi ke lapho ngezindaweni eziningi futhi nesikhathi bexhumana ngaso nomsola wesihlanu akusenjalo?
That is correct, my lord.
Athi yebo kunjalo.
And without the information that was furnished by accused number 1, would you have been able to locate Mr. Zwani, Mr. Lionel Zwani, the traditional healer?
Bathi ngaphandle kolwazi olutholile lapho ke kumnomzana ke osibiya ke ngabe bongakhona yini ekhize emthola ke isangoma noma inyanga leyo ke uLion Zwane?
No, that would not have succeeded in finding the traditional healer, my lord, particularly because he did not provide the address. He only said he can identify the house as he did not recall the physical address.
Athi cha bekuzoba nzima ke lokho ngoba wena wasithatha akalazi ke kheli lalo muzi ke loyo ke kepha wasitshela nje isikhangiso somuzi bese wasathatha wasikholisitshengisa ke loyo muzi loyo.
Thank you, my lord. Those are the only aspects we wanted to take up with the witness. We'll request that should perhaps further evidence come to light, that we'll then request that he should be recalled, my lord.
But Mr. Mnisi said he wanted to cross-examine the brigadier.
Yes.
You remember, we've forgotten.
Yes, on the aspect of Wabeni.
Yes, that's what he said.
Yes.
Are you going to do it now, sir? Or you want us to postpone?
I did not get what was happening, my lord. I was busy.
You didn't get what?
I think the court is inviting me to do something. I just did not get what is the record.
You said you were going to do that something. I want to cross-examine the brigadier about that information when he says that Gwabeni Zungu is afraid to come and testify because he fears to be assassinated.
I will do it when he comes back, my lord.
I remember all the evidence, funny enough.
I will do it when he comes back.
So, what do we do? We postpone.
My lord, there is one thing with the court indulgence aspect that I would also need to bring to the attention of the court in its entirety. The court would recall that I intimated a few days ago that we were to request for the recalling of Mr. Constable Zungu, and the indication was that I need to bring a formal application, my lord.
Yes.
Yes, this is their application, my lord. It's exclusively based on one point, my lord, that the court would recall that the Constable Zungu...
No, I said.
Yes.
You must bring a substantive application.
Yes, my lord.
Yeah, substantive application on paper.
Thank you, my lord.
So that the state can respond, and me also, I can read it.
Yes.
And go and prepare.
No, it's fine. I will.
Okay. What do we do about this inspection in local? When do we hold it? Monday?
Well, my lord, as we indicated that security arrangements need to be made
Yeah,
first.
I know that. So
we need to communicate with correctional services and Once we've received the go-ahead from them, we can then proceed with the inspection in loco. The one possibility, my lord, that we suggested was photos, aerial photos. I'm just wondering if we shouldn't first try that route. If it doesn't work, then we can, as a last resort, try the inspection in loco.
Yes. What's your view, Mr. Mnisi?
I'm not amenable to that suggestion, my lord.
Okay.
Because with an aerial photo, I still have to apply imagination as to what is it that could be contained in this. When this point is here, what would then be here? It will also need a lot of interpretation when I go through that photo, my lord. I think the easiest way is just to go and have it's a veni vidi vici kind of a situation, my lord. Thank you.
Okay. Mr. Ramsepin?
My lord, as the court places, I do support Mr. Mnisi because we should recall, my lord, that accused Mr. Sibia says it was a secluded place where he was taken to. I don't think aerial photos and the like will do justice to his version to and instruction to Advocate Mnisi.
Mr. Umalo?
My lord, I will support my colleagues' submissions. Thank you.
Mshololo?
My lord, inspection in logo it's a physical site visit of the crime scene of the area to be inspected.
No. What does that mean?
Support.
Sorry, my lord. In other words, my lord, I mean, if I'm saying it's a physical site visit, it means, my lord, it has to be done physically, not by way of visual pictures. Thank you.
Okay, fine. So Monday, what do we do Monday?
Well, there was a request yesterday by Advocate Mnisi. If that request is granted, my lord, we can resume them on Tuesday.
Okay. See you Monday then.
ngomsombuluko kwasebelizayo ke